please call Zoom at, and I'm going to give you a phone number here, so write this down, 888-799-9666, extension 2. Please do not call or email us with technical questions about Zoom. We do not have the capability to deal with that, unfortunately. Everyone who's watching the webinar is going to be muted. If you have questions, please type them in the chat box. You can find the chat box at the bottom of the screen. I'll be following along in the chat box to see if people have questions, and depending on if they seem like something we should jump in with, I'll jump in, or maybe we'll wait until the end of the presentation, depending on the judge's flow. The webinar, again, is being recorded, and it will be on the commercial web page. And our presenter today, as you can see, is Judge Al Cercone. He is a Justice of the Peace in Dallas County and presides over one of the busiest courts in the state. He is also a faculty member at the Texas Justice Court Training Center, where all Texas Justices of the Peace are required to attend annual continuing legal and judicial education. Judge Cercone knows his stuff, and we are very fortunate to have him here and have him making this presentation this morning. So with that, I'm going to mute myself. I'm going to hand this over to the judge, and Judge Cercone, please.
Very good. Good morning, everyone. I hope you have your cup of coffee ready and don't need a break, because we're going to probably roll right through. But it's a pleasure to meet with you again on a webinar. And today we're going to talk about commercial evictions, possibly a couple of other little things that deal with commercial properties, specific to commercial property. And certainly if you have any questions, either ask them during the process of the presentation, or send me an email, or call me. I'm giving you on that first screen my email address and my office phone number. So if you have a question, best way to do it is to email me, and when I have time, I'll look at it and I'll answer all your questions. There might be some limitations to what I can tell you because of the limitations given a judge with regard to giving legal advice, but procedurally and generally, just about anything you might normally ask, I'll be happy to answer for you. Knowledge is power, and these are your tools. So let's get on with it. There are many types of eviction processes, but the eviction process is essentially the same for all, whether it's residential, commercial, or manufactured homes. And those are homes that are only in a manufactured home community, not just a manufactured home if there's only one or two sitting on someone's property. But anyway, the eviction process is all the same for all of those. So there's no reason to complicate yourself by thinking that they're different for some reason, because they're not. You're allowed to ask for money damages for rent only in an eviction, but that limit is $10,000. And that doesn't mean it can't be greater than $10,000, because if, for example, your rent is $8,000 a month and you file an eviction for the $8,000 that hasn't been paid, if another month crosses the deadline when it's due before you actually get to court, you can add another 8, which would make it $16,000. And that's what I mean by the mere passage of time, because these things are due monthly. You're not allowed to ask for other damages like damage to your property, or missing items, or late fees, or other things like utilities that might be part of the agreement. You're limited to asking for rent only in an eviction. Now, you can always bring those suits for those other damages in another separate civil lawsuit, but it wouldn't be an eviction, because evictions are designed to be extremely fast so that the rightful person can take possession of that property. Commercial property is broadly defined in the property code, and the property code is where you want to find really everything you need to know about this, and the appropriate chapter of that is chapter 93. It defines commercial property as rental property that's not covered by chapter 92. So it's kind of an interesting way to define commercial property. Chapter 92, of course, is residential property, and it's a rather large chapter. And if you look in the property code, you'll see that chapter 93 is extremely small compared to chapter 92. It's probably only 3 pages or so, and there are many, many pages dealing with residential eviction, because people's homes provide them with a lot more rights than a commercial tenant. Chapter 94, if you had any interest, is manufactured home communities, but chapter 93 is your Bible for commercial landlord-tenant relationships. Rule 510 of the Texas Rules of Civil Procedure governs the eviction process for all evictions. And like I said, all evictions are the same. The Rules 500 through 507 are in the Justice Court section because Justice Court has original jurisdiction for all eviction suits. And that part of the rule also has to be complied with, but we'll go over that. Anyway, 510 is the main rule. These rules are all new. The Texas Supreme Court decided to change all the rules for Texas justice courts, and that change took effect August 31st, 2013. 500.4a and b of the rules, and if you'll just look, it's easy to find, but that's how they number them. Says that any individual may represent himself or herself. And as a matter of fact, you don't have to have a lawyer in any court in this country, regardless of what type of lawsuit it is. It's probably not prudent for some types of lawsuits to try to prosecute these things or defend them without an attorney representing you, but the law doesn't require anyone to have an attorney. However, if you're not the individual, an authorized agent can represent anyone in eviction suits. And if it happens to be a corporation or any other entity, any other business, a corporation or any other business who owns the property, then an employee, owner, officer, or partner of the entity who is not an attorney may represent anyone in an eviction suit. And certainly, you may be represented by an attorney. The property manager or other authorized agent is authorized in an eviction suit, even for a business. So it's pretty liberal on who can represent parties in eviction suits. There's also a section called assisted representation. So if you happen to be an individual, but for some reason you're not really capable of doing this by yourself, and you have a family member or somebody that you think might be able to help you, and they're not an attorney and they're not getting paid, the new rules allow for that also. So the court can consider it, you can ask, and for good cause, allow an individual representing himself or herself to be assisted by a family member or another individual who's not being compensated. Almost everything we do in the courts especially has to do with time. Time is extremely critical, and the rules set out how we're supposed to define and interpret time. So when we compute a time period, especially in the new rules, you exclude the day of the event that triggers the time period. For example, if you file a document today, you don't count today for any purpose. If you receive a judgment today, you do not count today. So tomorrow is day one, anytime you calculate periods of time. And you count every day, including Saturdays, Sundays, and legal holidays. And you include the last day of the period when you count it, unless that last day falls on a Saturday, Sunday, or legal holiday. And in the event that it does, then the last day, but only the last day, can be moved to the next day that's not a Saturday, Sunday, or legal holiday. And unfortunately, they threw this in, a little caveat that makes it a little more complex. So you have to find out what court you're dealing with. If the court you're dealing with closes before 5 p.m., then you have to add one more day for some reason. We close at 5, so we don't have to be concerned about this. Many courts did move to closing at 5 o'clock, but many of them still close earlier than that, 4 or 4:30. And in courts where that's the case, any document that has to be filed, you get an extra day. In order to initiate an eviction suit, you have to file a petition. It's what you file to start any type of civil lawsuit. But the petition must be sworn to, so it's something you have to do under oath. The petition has to describe the address of the premises that the plaintiff is seeking possession of. It has to describe the facts or the grounds for the eviction. You can't just leave it blank. The purpose of the petition is to serve notice upon a defendant, in this case a tenant, why they're being sued. A description of when and how the notice to vacate was delivered. Now, notice to vacate is a requirement in Chapter 24 of the Property Code, and it spells out all the different circumstances where you might have to give a notice. So that's important for you to know also, Chapter 24. You might want to write those down. Chapter 24 of the Property Code is the notice provision, Chapter 93 is commercial tenancies. But before you proceed with any eviction suit, you have to first give a tenant to voluntarily vacate the property. And if they do so, there's no reason for an eviction. If you give someone a notice to vacate, which is a demand for possession, and thereafter they don't voluntarily vacate your property, that's when you have the right to file the eviction, because you're seeking the court's help to get the tenant out, since they won't voluntarily leave after you gave them notice. You can include the total amount of the unpaid rent due at the time you file the eviction. And if it accrues beyond $10,000 by the time you get to court, like I told you before, that's okay. And if you're going to ask for attorney's fees, you need to have that statement included in your petition. The notice to vacate shall be given specific ways, or it's not really correct. And this is probably one of the biggest problems that landlords have, one of the biggest mistakes that they make. And sometimes their suit has to be thrown out because they didn't follow the proper procedures. So procedurally, you always have to give a notice to vacate before you ever file an eviction. And you have to wait until the notice time period expires before you can file. So the notice has to be delivered in person to any person residing at the premises who is 16 years of age or older. You can send it by regular, registered, or certified mail, but the law only requires regular mail. So it can be by personal delivery to the premises by affixing the notice to the inside of the main entry door. Now, that's not the storm door or the screen door. That's inside the premises. So the main entry door, attach it to the inside. That's good delivery. The notice period is calculated from the date of delivery. And the notice to vacate must be unconditional unless you've sent previous written notices giving the tenant notice of how much money they're behind and how much is due. It's not a good idea to send multiple notices because the court may be confused. And if the court gets confused, you might not get the result you're seeking because the court doesn't understand. Now, that's probably a good time for me to raise this point. I teach these same courses to judges all over the state. There's about 821 justices of the peace in Texas, and those are the courts of original jurisdiction for eviction suits. Some of them are new. Some of them are lawyers and don't think they need to learn anything. Some of them have a way of doing things that might be contrary to the law or the rule, and they're comfortable with that, so that's the way they're going to do it. So what I'm saying is, you may not find a judge, or you may find a judge, unfortunately, who may not follow the law and the rule exactly like they're supposed to. That's something you kind of need to learn the hard way. It's not proper, they shouldn't do it, but it's a fact of life. So what I'm telling you is what the laws and the rules say specifically. A court with a good judge should follow them exactly like I'm telling you. If they don't, you might find out what those idiosyncrasies are about that court prior to filing a suit, and then maybe customize the way you have to do it in that judge's court to get the same results.
Judge Cercone?
Yes.
Can I ask you a quick question?
You can ask me a slow question.
You said that the notice is required to be delivered to somebody who's residing at the premises. How does that work for a commercial property if there isn't somebody who resides? What would be the correct person who would have to get the notice in that circumstance?
Well, in a commercial property, you've got an agreement with certain people to occupy that property. And if it's a business name, certainly you wouldn't, but I would think it would be easy enough to attach that notice to the inside of the main entry door, and that would satisfy the law as far as delivering the notice. The good news is the law doesn't say they have to receive it. It just says that the landlord has to deliver it. So you can imagine if I had 170 evictions in my court at one time in one day at 10 o'clock in the morning, and I have had that. If the first tenant came up and said, well, I never received my notice, and then if I threw the case out because I believe they didn't receive it, imagine how many times I'd hear that same defense. So it's not a defense to say I didn't receive my notice. It's something the landlord has to prove that he delivered the notice. And so if it's an agent of the company in the premises, that would probably be great. It would almost be the same as if you were trying to sue a company for any other purpose. That person that needs to receive that and probably not the registered agent for service, but one of the principals of the company or manager of the company.
Okay, great, thank you.
It's something that it would have to go to court to find out for sure. But certainly you could post it to the inside of the door. And if it were my property, and I have commercial property, I would post it to the inside of the door and hand it to someone. And I might even mail it at the same time. Be difficult to not receive it if you did all of those things. But it's so common for people to mail something. When they mail it, not just mail it by regular mail, but also certified mail. And even if the certified mail comes back, the regular mail generally doesn't. So whatever you can do to show the court that you did deliver the notice, the court has to believe it, and your oral testimony is evidence, so that might work. But kind of a complex question.
But it was a good answer, thank you.
Okay. Getting on with the petition, it must also include the name of the plaintiff, that's the landlord, the name, address, telephone number, and fax number, if any, of the landlord and the landlord's attorney, if applicable, the name, address, and telephone number, if known, of the defendant, and if the plaintiff consents to email service of the answer or any other motions or pleadings, a statement consenting to email service and email contact information. So when you file this petition, you can include your email address and say that's good enough for you to be able to communicate with me, the landlord. Sometimes that's the fastest way to communicate, because otherwise the court would probably have to mail something. So it's a handy tool that you can use now to get information sooner than later. Your eviction petition must be filed in the Justice of the Peace precinct where the premises is located. So if the property you're trying to evict someone from is in a different precinct than where you file it, it has to be dismissed. So you need to make sure and file it in the right precinct. The plaintiff will not be entitled to a refund of filing fees if they file in the wrong precinct. And they may not be entitled to a refund of service fees, but if it hasn't yet been served, you could be refunded the service fees. Remember, the claim for rent is limited to $10,000. So it could be $10,000 on the day you file it, but you're not allowed to arbitrarily reduce the amount of actual damages. So if they owe you $10,000 and 1 penny, you can't ask for rent damages. You can't just say, well, I'll just credit the penny and ask for the 10. This isn't court TV. You can't do that. Now, what the court is going to do in an eviction suit is adjudicate the right to who has actual possession of the property, not discuss the title. So even if there is a title dispute, it's not for the Justice of the Peace Court to consider. Counterclaims that you might see in normal lawsuits, joinder of other claims in the suits, maybe bringing in third parties, none of that's permitted in an eviction case. That doesn't prohibit a person from bringing up those causes of action that might otherwise be required in a lawsuit. There are things like compulsory counterclaims. So you're suing me about an issue between these two parties. If I don't file the counterclaim, I lose the right to bring the claim. But that's not true if it's an eviction suit. You still have the right to bring that separate claim. Citation has to be directed to the tenant, and it must state the day that the tenant, defendant, must appear in person for trial from the court that's issuing the citation. And that trial date's not going to be less than 10 days or more than 21 days from the day you file the petition. You're going to be given the trial day when you file. The citation will also notify the defendant that if they fail to appear for trial, that they may have a judgment by default entered against them. And it has to inform the defendant that upon timely request and payment of a jury fee, which is not later than 3 days before the day of trial, that they're entitled to a trial by jury. So when you go to court to prosecute these eviction suits, you need to be prepared to present it before the judge. And that should be just as much preparation as you would need to present it before a jury, because it might be a jury trial and you may not know about it because of the way the timing is. You may not have been given time to know it was going to be a jury trial and prepare for that, but it shouldn't be different. If you're prepared to prosecute your eviction suit before a judge, you should be prepared to prosecute it before a jury. there's a little tool that you can utilize to help you gain possession of your property sooner than later. And it's not utilized as much as I would think. As a landlord myself, I always do it because it's a great tool. And you don't have to follow through on it, but it does give you the opportunity to get possession of your property sooner than later if that's what you choose to do. And it's called filing a bond for immediate possession. So you'll be required to post a bond. The amount of the bond has to be approved by the court. So the judge will set the bond amount. Some courts, like I do, set it at a fixed amount. A bond for immediate possession of my court is $1,000. And it's conditioned that the plaintiff will pay the defendant all costs and damages that might be adjudged against the plaintiff in the event that you're filing a bad lawsuit. The defendant's going to be receiving a notice that tells them that a bond for immediate possession has been filed. It has to be served on them with a citation. So it's important that you file these at the same time you file the eviction petition. And then they both get served at the same time and you don't get charged an extra service fee. Has to inform the defendant that if he doesn't file an answer, and that's a written answer, or appear at trial, then if a judgment for possession is granted to the landlord by default, that he could lose possession right then. Otherwise, you have to wait until the tenant's appeal period expires. So the bond for immediate possession is a pretty valuable tool. You file it when you file a petition. If the tenant does not submit a written answer to the court and then fails to appear at court, you should be winning a judgment by default. And then after you have that default judgment, you can immediately ask the court for a writ of possession. Once that court issues that writ of possession, you're going to get possession of your property back. Now, if that tenant comes in and appeals after the writ is issued, it's too late for them to keep possession. They will still have their case appealed to the next court, which is a county court or a county court at law, but they just won't be in possession of the property during the appeal. Many tenants appeal just to stretch out the time. So this eliminates that abuse of the rule. The time for issuance of a writ as soon as it's ready. If you have an immediate possession bond, the court must issue it immediately upon demand. So in my court, if you had a bond for immediate possession filed, I grant you a default judgment. You can then go to the counter and ask the clerk for a writ. And this all takes place in a couple of minutes. If you don't have a bond for immediate possession, the writ must not be executed before the 7th day after the date. I'm sorry, this has to do with the bond for immediate possession. I can't hit the backspace on myself. Sorry about that. The writ must not be executed before the 7th day after the date the defendant served with the notice. But that's sooner than they could normally do it if you file it with the petition. So that timing is probably important. If the defendant appears, like I said, then you have to wait until the appeal period expires before the writ can issue, and that's no sooner than the 6th day after the judgment is signed. And it literally follows whenever the appeal period expires. So when you go back to the rule that we talked about initially, computation of time, that can be more than the 6th day. Weekends and holidays can stretch it out. So technically it's after their appeal period expires using the computation of time rule. The defendant must appear for trial on the day set out in the citation. The defendant may, but is not required to file a written answer. If the defendant fails to appear at trial and fails to file an answer before the case is called for trial, and proof of service has been on file for at least 1 day with the court, the allegations of the complaint must be taken as admitted and judgment by default rendered accordingly. Now, this is a change in the rules. When those new rules took effect, the language was changed to essentially make a judge give you a default judgment. Not all judges would do that before. In addition to the fact that they don't all pay attention or keep up, some of them are very pro-tenant friendly, and that's inappropriate for a judge. A judge should be an impartial trier of fact, not care who wins or loses, allow the facts and the laws to help them decide who should win the case. But if you have a bias or a prejudice, it might influence your decision so much that you just rule against the landlord because you don't want to kick a tenant out. And that's inappropriate. But the rules were changed because of judges like that. And the rules say when you file your written sworn complaint, your petition, which you've already sworn to, if the defendant hasn't written an answer and hasn't appeared for trial, the judge has to take that complaint as good enough to prove your case and grant you a default judgment.
Okay.
So that's a benefit to you.
I'm sorry to interrupt you. We might need to go back a little. I have a few questions here about lockouts. I know you just went over that. Maybe we need to clear a few things up. Somebody has asked, when can you lock a commercial tenant out? And someone says, maybe I missed it, but why not just lock the tenant's door and post notice of lockout and contact info?
You can only lock them out if they're behind in their rent. There might be other reasons, 100 other reasons why you might have a right to evict. So what we're talking about now is the eviction procedure, which you can do for non-payment of rent or any other major default of your agreement with the tenant. I will get to the lockout procedures because that's something I put on the end of the eviction procedures if you want to wait a second.
Okie dokie, will do.
Okay. Okay. Jury demand, I mentioned earlier, it has to be no later than 3 days before the trial date. So it's possible that you could call the court and find out if a jury demand has been made. Then you would know to come to court prepared to present your case in front of a jury. Some of you may be more comfortable at hiring an attorney at that point. Wouldn't be necessary, but you certainly have the right to do it. And if you're not comfortable doing this in front of a jury, hire a lawyer. They have to pay a fee when they ask for a jury, and they have to sign a statement that says they'll be responsible for paying for the impaneling the whole jury in the event that they don't show up. Trial in an eviction case must not be postponed for more than 7 days. So if someone asks for a continuance, the longest a court can postpone it is 7 days unless the parties agree to a longer period of time in writing. And it happens a lot in commercial evictions when the landlord and tenant are trying to work out their differences. But the trial court, once the case is filed, cannot postpone the case by itself for more than 7 days, only by written agreement of the parties. Where a jury has rendered a verdict, the judge may render the judgment on the verdict. In other words, he may sign a judgment that is consistent with what the jury decided. There's something that's not well known. In civil cases only, the judge has the power to essentially decide the case based on what the facts and the evidence said it was. So if it's contrary to law or evidence, the judge can essentially change the verdict. So if the jury comes back, it was admitted that the tenant's behind in their rent, that proves the plaintiff's case, but the jury was sympathetic and said, you know, we're just not going to give the landlord the judgment. The judge can overturn that verdict, grant judgment for plaintiff. It's called a JNOV, which is an acronym for the Latin term judgment non obstante veredicto. And that's what it means. It's not common. It's certainly not popular in front of a jury to say, well, we're just going to ignore what you said. But I would certainly consider it if the evidence did reveal that the jury decision was contrary to the law or the evidence. I might excuse the jury first, let them go, thank them for their service, and then change the verdict. If the judgment's in favor of the plaintiff, the landlord, the judge must render judgment for plaintiff. For possession of the premises, cost, delinquent rent as of the day of entry of the judgment, if any, and attorney's fees if they're recoverable by law. In order to get attorney's fees, let's talk about that for a second. You're entitled to get attorney's fees one of two ways, either statutorily or contractually. So if your contract provides for attorney's fees for either party if they have to sue, and both parties sign the contract, then both parties have agreed to pay attorney's fees, and those are called contractual attorney's fees. So that's all you have to do, have a contract. I assume all of you use standard contracts, and that language is in there, so you're probably covered. In the event that your contract does not say that, or in the event that your tenant didn't sign the contract, and so really they can't be bound by the terms of the contract, then you'd have to send a notice to vacate by certified mail, return receipt requested, giving them at least 10 days to vacate, and also say in the notice I'm going to seek attorney's fees. That would be following a statute in Chapter 24, and that would allow you to get statutory attorney's fees. So either one of those would allow you to ask for attorney's fees. And in all civil lawsuits, if you want attorney's fees, the attorney needs to be present to testify, give evidence of how much those fees should be, and allow himself to be cross-examined on the veracity of his statements about his fees. If the judgment's in favor of the defendant, the judge must render a judgment for the defendant against the plaintiff or the landlord for court costs and attorney's fees if they're recoverable by law. Now, if your contract says that you can recover attorney's fees, it automatically means the tenant can. And if your notice saying that you're going to seek attorney's fees by certified mail and giving them 10 days allows you to collect attorney's fees, it's only fair that it also allows the tenant to be able to recover attorney's fees. So what's good for one is good for both. The writ of possession, and writ means order by definition. The writ of possession is the tool that you would use to ultimately get possession of your property from a tenant who refuses to vacate voluntarily. That writ is an order by the court sent to the constable's office or the sheriff, depending on where you live, ordering them to make sure you get possession of your property back. Now, if there are furniture, fixtures, equipment that need to be moved out of that office space or commercial space, you have to provide the labor to do that. The deputies aren't going to move. They're just going to stand there with their badge and gun and make sure it's a peaceful transition. But the judge must award a writ in order to give you possession, and you get it anytime you demand it. Unless you have a bond for immediate possession, you can't get it before the 6th day after judgment. We talked about that a little bit. And it's only good for 60 days. Or you only are entitled to get it for 60 days after the day the judge signs the judgment. So the date of the judge's signature is what starts that clock ticking. And you only have 60 days. Now, for good cause, you might be able to convince that court to extending that deadline to 90 days, but under no circumstances can it be over 90 days. And specifically, 510.8D2 of the Rules of Civil Procedure say a writ of possession may not be executed. That means the deputy can't work it after the 90th day after a judgment for possession is signed. And the writ of possession must not issue if an appeal is perfected, and if applicable, rent is paid into the registry as required by these rules. There's no motion for new trial after an eviction judgment in the JP court. So once the judge renders his decision, it's done, it's final. The only remedy for a tenant or a landlord is to appeal. A party may appeal a judgment in an eviction case by filing an appeal bond, making a cash deposit for the bond amount, or filing a sworn statement of inability to pay with the justice court. Now, if you own commercial property, you're going to be hard pressed to convince the court that you can't have the ability to pay for a bond. For tenants, it might be a little easier. You have to do it within 5 days after the judgment's signed. So the appeal period for an eviction judgment, for any kind of eviction, is 5 days. But remember computation of time. The judgment may get signed today. Day 1 starts tomorrow. Day 5 cannot be on a Saturday, Sunday, or legal holiday. And if it is, it goes to the next day. It's not a Saturday, Sunday, or legal holiday. And if that court, for filing that bond, closes before 5 p.m., it goes to the very next day. So it could be a lot more than 5 days. Sworn statement of inability to pay the appeal bond for a tenant. If they file that statement, it has to meet the requirements of Rule 502.3b. The statement may be contested by the landlord, as provided in 502.3d, within 5 days after them filing that bond. So if you think about it, we're starting to extend the times just a little bit. They have 5 days to file the appeal. If they file it on the last day and you contest it because they filed it by saying they couldn't pay a bond, then we have to notify you, give you 5 days to contest it. Then we have to have a hearing if you do. Anyway, all of it together can extend things out. If the tenant does appeal by filing a statement of inability to pay, the court must provide to the defendant a written notice at the time that they file it, and it has to contain in bold or conspicuous type the amount of the initial deposit of rent. That's if the suit was for non-payment of rent. And it's specifically to eviction suits for non-payment of rent. So if that's the grounds for the eviction, the tenant will be required to pay 1 month's rent into the registry of the court within 5 days of the day they file that appeal saying they can't afford to post a bond. So it's taken away their ability to abuse the process just a little bit, because now they're still going to have to pay rent. And then they're going to continue to pay rent every time it becomes due during the course of the appeal. The notice the court has to give them has to tell them how they do it, who they make it out to, by what form of payment they use, cash, credit card, not credit card, well, I guess it could be, cashier's check, money order, whatever, and who to make it payable to. The calendar date by which the initial deposit must be paid into the Justice Court Registry has to be in that notice, and it must be within 5 days of the day they swore to it and filed it. A statement that failure to pay the required amount into the Justice Court Registry by the required date may result in the court issuing a writ of possession without a hearing. A defendant who appeals an eviction for non-payment of rent by filing a sworn statement of inability to pay is entitled to stay in possession of the premises during the pendency of the appeal by complying with the following procedure. Within 5 days of the date the defendant files the sworn statement of inability to pay for an appeal, the defendant must pay into the court the set amount that the court gave them notice of. If the defendant was provided with the notice and fails to pay the designated amount into the court registry within 5 days, and if the transcript from the JP court hasn't been sent to the county yet, then the plaintiff's entitled, upon request and payment of the applicable fee, to a writ of possession, and that'll give you possession of the property back, and that's without a hearing. So if the tenant files an appeal by filing a pauper's affidavit in a non-payment of rent appeal, and this only applies to non-payment of rent eviction suits, if they fail to pay that rent on appeal into the court, then you can have possession of the property the day after they fail to pay it. The appeal will still go up, but they're not going to be in possession of the property. If the defendant fails to pay the designated amount into the court registry within the time limits prescribed by these rules, the plaintiff may file a sworn motion that the defendant's in default in the county court or the appeal court. The plaintiff must notify the defendant of the motion and the hearing date. Upon a showing that the defendant is in default, the county court must issue a writ of possession. I hope that happens. I've heard stories where that won't happen sometimes in those courts also. Those are all lawyer judges, and sometimes they're creative thinkers. And while creative thinking is a great, great asset for a lawyer, it's not good for a judge. The plaintiff may withdraw any or all rent in the county court registry upon a sworn motion and hearing, prior to final determination of the case, showing just cause, dismissal of the appeal, or order of the court after final hearing. All hearings and motions under this subparagraph are entitled to precedence in the county court, and hopefully they'll give you precedence on those hearings. But once again, money that's paid by the tenant into the registry of the court, whether the JP court or the county court, is yours after you file a sworn motion and ask for it. The writ of possession or execution, or both, will be issued by the clerk of the county court after the appeal. And the same will be executed by the sheriff or constable as in all other cases. The judgment of the county court may not be stayed unless within 10 days from the judgment, the appellant files a supersedious bond in an amount set by the county court pursuant to section 24.007 of the Texas Property Code. Okay, that pretty much concludes the eviction process. And there was a lot there, but it's just not really a complicated process. And if you haven't done it or you're not experienced with it, talk to people that are, and I would strenuously encourage you to go to the court where your property is located and watch that court conduct eviction hearings just to see what they do, what idiosyncrasies they may have, what things they like and don't like, what they accept and don't accept. this would be a valuable experience because it may tell you what you should or shouldn't do if you notice that that court will not accept something or will always accept something else. So the courts are open to the public. You should be able to go into any of those courts anytime you want and observe just for that purpose. And if you're in a community where it's likely that the judge would have lunch with you, if you don't have a case pending, not a bad idea. A one-on-one is very good. And you might even ask him, what do you think is reasonable or unreasonable about the way landlords prosecute eviction suits? And he'll probably tell you, or she'll probably tell you. But it might be valuable to do that. Might cost you lunch, but that's okay too. The judge probably shouldn't take a lunch, but and I don't mean the break, I mean the gift. But you might be able to do that. Okay, let's talk about exclusion and removal of property. The landlord may not interrupt utilities paid for by the tenant or remove window covers, doors, latches, etc., except for bona fide repairs, construction, or emergency. The landlord may not prevent tenant from entering the premises unless there are repairs or emergency. They are removing property of an abandoned tenant or the tenant's delinquent in paying at least part of the rent. Now, when you have an agreement with a tenant to pay rent, they have to pay all the rent. If the rent's $2,500 a month, $2,495 doesn't cover it. It has to be the full $2,500. So if they're behind in the rent at all, then they're delinquent in part of the rent. And if they're behind in their rent, you have certain rights. This is in Property Code 93.002 A, B, and C. The rights of a lockout commercial tenant are much less expansive than those of a residential tenant. A landlord must post a written notice on the tenant's front door stating the name and address of the person from whom a key can be obtained. Now, if you don't do this, it's an illegal lockout and you can be punished for that. So if a tenant's behind in their rent at all, any amount, you can lock them out, but you must post a written notice on the tenant's front door stating the name and address of the person from whom a key may be obtained. With cell phones and every other electronic device that we have, you can take pictures of this. You can have a witness with you, which is a good idea. You can take pictures of the witness with you standing next to the notice that you posted to the door. This is going to be great evidence if they say you didn't post the notice. So you should record or document everything that you do the best you can. But like I said, with cell phones, everybody has a camera, so it's just too easy to do it. And you don't have to develop those pictures on cell phones, so it doesn't cost you anything. But it's good evidence. And in that regard, almost everything that you do when you communicate with a tenant, you should do it in writing so that it can be documented. And if you're going to do that, bear in mind, these documents, these communications may be read by a jury. So be careful what you say and how you word your communications with the tenant. Be the good guy. Let the tenant be the bad guy. The key that you said could be obtained in that notice that you left on the door when you locked out the tenant is only required to be provided during the tenant's regular business hours and only if the tenant pays the delinquent rent. So I believe the question earlier was, why not just lock them out and be done with it? You have to lock them out properly. You have to make sure you give the right notice. And if they pay the rent that's delinquent that you put in the notice, then you have to give them the key back. So it sounds like you're trying to do a self-help eviction without going through the court. And it's kind of allowed based on the lockout. If they can't pay the rent and they don't, you lock them out and they might be gone for good. Commercial tenants can apply for a writ of reentry after they're locked out. That's in 93.003, the property code. If the landlord locks out a tenant in violation of this reference section, requiring you to post the notice, requiring that they had to be behind in rent, requiring certain language and contact information in your notice, then the tenant can seek the writ of reentry and terminate the lease if they want, or recover possession of the property and recover damages that you've caused them for 1 month's rent or $500, whichever is greater, plus attorney's fees, plus court costs, minus any amounts for which the tenant may be liable to the landlord. So if this ever happens to you and the tenant owed you some money, be sure and tell the court to give you the credit for the amount of money that the tenant owed you. Waiver of lockout rights. Commercial tenants can waive their lockout rights in a signed written lease. A lease supersedes this lockout section to the extent of any conflict. That's literally what the law says, 93.002H. So you could have in your contract a provision where you agree with the tenant to waive the lockout provision. Abandonment of the premises can be presumed if the landlord notices goods, equipment, or other property in an amount substantial enough to indicate probable intent to vacate, has been removed, or is being removed. If the removal of the property is not within the normal course of the tenant's business. So if the tenant has a furniture store and you see furniture moving out, that might not imply that they're abandoning the property. That's in Property Code 93.002D. A landlord may remove and store the tenant's property if the premises are abandoned. The landlord shall then deliver by certified mail notice that the landlord may dispose of the property removed if the tenant does not claim it within 60 days. The landlord may then dispose of the property if the tenant does not claim it within 60 days after the date it's removed and stored. That's in the Property Code 93.002E. Again, Property Code Chapter 93 is like your Bible. You could memorize it. It's only a few pages, but it's extremely important that you do review it so that at least you know where it is in case you need to look it up. You need to also keep yourself up to date because when the legislature meets, sometimes they surprise us with new laws. That's every 2 years. And if they've changed one of these laws that you think you knew, you don't know it once it changed. So it's important that you keep up. It's part of your profession. It should be one of the tools of your trade. Security deposits. A landlord must refund a security deposit no later than the 60th day after the tenant surrenders the premises, after the tenant provides written notice of the tenant's forwarding address to the landlord or the landlord's agent. A landlord may not deduct things from the deposit for normal wear and tear. And deposit refund claim by a tenant takes priority over any creditor of the landlord, including a trustee in bankruptcy. Charges that you might assess other than damage by taking monies out of that deposit, unless it's physical damage, the amount of the charges or the method of computation has to be stated in your written lease or agreement. And again, if you both don't sign it, you don't have a written lease or agreement. It can be an exhibit, attachment, or amendment to your lease. And that's also articulated in the Property Code. Literally everything I've told you is going to be in the Property Code in Chapter 93, Chapter 24, or in the Texas Rules of Civil Procedure in the 500 sections, mostly starting with 510. So I'm not making any of this up. You can look it all up if you like. If the landlord's interest is terminated by sale, assignment, death, appointment of receiver, bankruptcy, or otherwise, the new owner is liable for the return of the deposit from the date acquired. The previous owner remains liable until the new owner delivers a signed statement of acknowledgement confirming receipt and specifying the amount. This does not apply to a real estate mortgage lien holder who acquires title by foreclosure. Tenants and landlords have remedies if either acts in bad faith. The landlord has 60 days to refund the deposit or send a written notice of deductions before bad faith is presumed. A tenant who withholds the last month's rent is liable for 3 times the rent plus attorney's fees. A landlord who wrongfully withholds a refund is liable for 3 times the amount of deposit plus $100 plus attorney's fees. Okay, that pretty much ends that presentation. I was going to tell you one other thing about a security deposit, and the security deposit is designed, and by definition, it's to secure faithful compliance with the agreement between the landlord and tenant. The security deposit is not intended to be rent, ever. It's not intended to do anything other than secure compliance with the agreement. So that's what a security deposit is all about. After the tenant leaves, whether or not they had to be evicted or they ended their lease and asked for their deposit back by sending you a notice of their forwarding address, they can't say, take my last month's rent out of the deposit. That's obviously something that they could be punished for. And you can deduct from it reasonable damages, not wear and tear. So that's pretty much the bulk of the general information I wanted to cover for you. And I'll certainly answer any questions that you have either right now or, like I said before, and here's my contact information again if you didn't get it. I'll be happy to read and answer your questions by email if you have them. If you have a procedural question, something that's just a real quick procedural question, the telephone number is good for that because my staff is very well trained and can answer probably anything you might want to ask about procedures. And if you have dealings with the Justice of the Peace Court for any other type of issue, we're very good at all of those. So feel free to exploit us if you need to. The judges and clerks all over the state do it on a daily basis. So you're welcome to do so as well.
I can attest to the professionalism of the judges' staff. They are terrific people. We do have a couple of questions on this end to answer. Going back to much earlier, someone asks, can a notice be emailed if they have signed a contract that they will receive notices by email?
That's a good question, and it's probably going to be a judgment call by the judge of that court because the property code doesn't provide for email. It says that you can deliver the notice by delivering it in person, giving it to someone 16 years of age or older at the property, by attaching it to the inside of the main entry door, or by sending it by mail. It doesn't provide any other way. So what happens is when you have a creative lawyer representing a defendant, they may come up and say, not proper notice. And that might be an argument many judges may buy because the law literally doesn't provide for it. So I wouldn't do it just yet. Hopefully the legislature will address that. They continue to make changes regarding the internet, emails, and things like that, but they haven't on that specific issue. So I wouldn't advise it just yet.
Okay, I have another question. This one sounds like a big one. What is the process for evicting squatters from commercial space? Obviously, they are not paying rent, and you don't have a lease that outlines the eviction process, nor do you have contact info.
Well, your lease wouldn't apply to someone that's just taken possession of your property without your knowledge or permission. So there are two types of evictions by definition. They're both defined in Chapter 24 of the Property Code. One is called a forcible detainer, and one is called a forcible entry and detainer. The forcible detainer is the lawsuit you file against the tenant that you know you have. There's some type of arrangement, verbal, oral, in writing, some type of agreement to give possession of a landlord's property to a tenant. So if the landlord then wants to take possession of the property back, they have to give them notice to vacate, and they have to fail to vacate upon receiving notice during the time given in the notice, and then file an eviction. And that's called a forcible detainer. Because they didn't give up possession of that property upon demand is what makes it forcible. So it's a forcible detainer. If someone acquired possession of a landlord's property, either by force or without the landlord's knowledge or consent, that's called a forcible entry. And so the landlord's still required to give them notice to vacate before they can evict. You're not going to just be able to call the sheriff and say they're squatters or they're trespassing, because they will not do anything about it. They'll say this is a civil matter, which means eviction suit. But if they did acquire by forcible entry, then you're not required to give them a written notice. You're only required to give them oral notice, and you're not required to give them a time period. You may give them a written notice. You may give them a time period. You're just not required to. Oral notice, no time is allowable. So you could say, you have no right to be in my property, get out now. And if they don't just get up and start leaving, you can go straight to the Justice of the Peace and file the eviction suit. That's a forcible entry and detainer. and they're both defined in the first part of Chapter 24 of the Property Code.
Okay. Somebody asks, what happens if the tenant does not provide a forwarding address?
Then you have no obligation to send them the itemized list of deductions from their security deposit. That 60-day window that you have to respond only starts when you receive a written notice of the tenant's forwarding address.
Okay, that's pretty straightforward. We have someone saying thank you, which is nice. Someone is asking, why is the TAR commercial lease silent? Oh dear, I think that's going to have to be a hotline question. I'm not sure that the judge can answer questions about the TAR forms. Another question here, while security deposit is not considered rent, can the tenant and landlord not mutually agree to have outstanding rent due applied against that deposit?
I don't know why you would. The law says that a security deposit is not to be used for rent. It's to be used for faithful compliance to the agreement. It doesn't make any sense that you would do that if you maintain the tenant and then you eliminate the security deposit. You have nothing to go back on. So again, that would be something that I would have to see in trial before I even thought about it. Sometimes you can ask a judge a question, and if it has to do with how he might rule on an issue, he's really not allowed to tell you. Judges are supposed to maintain that appearance of impropriety. I'm sorry. They're supposed to avoid the appearance of impropriety by maintaining impartiality so that you would not know how they would rule until they hear the facts and circumstances. And that's an interesting question. I'm not aware of a provision that would allow you to contract that away and then be able to call a security deposit rent. So just on its face, it doesn't sound like something I would encourage you to do.
Okay. When returning the security deposit, what should you do if you are unable to fully determine the amount of repairs? For example, you haven't gotten all of the invoices before your 60 days has elapsed.
Well, before I became a judge, I was in a couple of different businesses. One was commercial and residential construction. I could build a 2,500 square foot house in 60 days. So I can't imagine how you couldn't get an invoice for repairs or an estimate in 60 days. So don't drag your feet.
Fair enough. Does the 60-day rule for return of security deposit apply both to residential and commercial?
No, it doesn't. Residential doesn't give you that long. They only give you 30 days. So the laws are a lot more liberal in commercial evictions, just like the lockout notice. If you give a lockout notice in a residential situation, you have to give the tenant a key any time of the day or night they ask for it, and they don't have to pay any rent to get it. You just have to give it back. So you lock them out, you have to give it back without receiving any money. In a commercial relationship, if you lock them out for non-payment of rent, they can't get a key until they pay you.
Okie doke. And someone's asking about a copy of the presentation. Yes, we will have the recording of Judge Cercone's presentation up on the commercial webinar page of the Texas Association of Realtors website, which is texasrealestate.com. Does anybody have any further questions for the judge? I know that we have this one still about why the commercial lease is silent, but I am going to take that and give it to one of the TAR attorneys and ask them to get back in touch. All right, it looks like you've answered everybody's questions, Judge. Thank you so very, very much. We'll close this up now. Thanks again. Oop, are you still there?
Yes.
Okay.
That was my pleasure, and I'm happy to do it. So if you ever need me to do it again, just ask. I'm happy to do it.
All right, thanks. Just before we wrap up, I'd like to encourage everybody to join us for our next webinar, which is on May 17th. It will be taught by Rick Albers, and the subject is commercial real estate finance. The April webinar will provide CE credit. You can find a link to register for the next webinar on the commercial webinars page of the TAR website. And if you want to provide the webinar for CE credit, you'll need to contact John Hauser in our professional development department. He'll get you signed up. I want to thank everybody, especially Judge, and you guys have a great day. We'll talk to you soon. Thanks. Bye.